Oh, hey friends, Josh Yeager, Santa Barbara dog walker, and Trust and Estates Poppin' Jay, having conversations with friends about trust and estate administration. I'm here with the dog Dodger, and hey Dodger, let's let you off leash for a bit. He's so excited about this. Okay, go buddy. Oh yeah, let's find those squirrels. So, Kurt from Long Beach asks in the question feed, longtime viewer. So Josh, what's up with a non-probate asset anyway? And how should I think about those in the preparation of Grandpa's estate? Great question, Kurt. So there are assets that you put into a trust. Think of a trust as a bucket that you title assets in. The house goes in the trust. The investment account with Fidelity goes in the trust. Perhaps the stock certificates for the closely held business that runs a couple of gas stations goes into the trust. And whatever is in the bucket, the trust document describes how that asset is to be administered after Grandma and Grandpa die. But a non-probate asset is an asset that skips over or skips out of the bucket because there's some other writing. So common examples are RIAs, retirement plans, pension plans, 401ks, all of these kind of tax deferred environments. When you fill out your account with Merrill Lynch, the guy asks you, hey, who do you want to get this asset when you die? Who's the primary beneficiary and who's the contingent beneficiary? And the accountant writes in there, to my spouse as the primary and to the kids as contingent. So that asset, anytime that there's some sort of writing that says what is supposed to happen with an asset and that writing is associated with like an account statement or a custodial account, investment account, that becomes a non-probate asset. That means it can't go through probate and it's not governed by the trust. It automatically, by operation of law, becomes the beneficiary's asset at the death of the account holder, Grandpa, the guy that has the IRA or annuity or whatever it is. Now, where this creates problems, oh, hey, Dodger, thought I lost him. Where this creates problems is when the drafting attorney doesn't know that the instructions, that the beneficiary instructions on the IRA or whatever it is are different than what he drafted. So in the last 2 weeks, this has come up for me twice, where we're going through the balance sheet of the client. We got the house, we got the annuity, we got the checking accounts, adding up what is in the estate. But that annuity isn't really part of the trust. The client thought, oh, this is a trust asset, and when I die, whatever the trust says is what happens. But in fact, the beneficiary on the annuity was the prior wife, if you can believe it. Yeah, they had forgotten to change the beneficiary form on the annuity. Though the trust documents were consistent, give everything to my surviving spouse and then to the kids, that annuity asset wouldn't be governed by those instructions. So this brings up the really important point that I am a long advocate for and champion of, which is you got to do a review of all of your documents and stuff after the trust and estates attorney gives you the nice binder with his business card in front. Because there's things that the trust and estates attorneys are not responsible for, like making sure the title of your assets is correctly vested. That means changed to be coordinated with the trust. It's a quick process. Anados does it for folks. We call it the estate vault. We do it when Dad got a bad diagnosis, and it's pretty likely we're going to be settling his estate in the next 24 months. It is incumbent upon the eldest daughter, who is frequently the successor trustee and responsible for settling the estate, to go through this process with Dad. Say, hey, look, there's a couple of nits and gnats we got to tie out. Got to make sure that all of the beneficiary forms on the non-probate assets are coordinated with whatever plan you had. Because if they aren't, we're going to end up having a serious knot that we may have to untie. So check those beneficiary forms. Other things about non-probate assets, it's not just IRAs, retirement accounts, life insurance, all of those things where there's a beneficiary form. There's also ways of holding real estate and investment accounts where they pass automatically through their titling to the joint owner. A transfer on death deed would be an example. I, Josh, record a deed on my house that says transfer at death to my buddy Kurt, for example. And it would be outside of probate. It would be outside of whatever my trust doc said. So got to pull the deeds on the house. Got to look at the beneficiary forms. Got to have a sniffing nose for these non-probate assets and how sometimes they might snare the successor trustee and the administration. Thus ends my mini lecture for today. Hey, Dodger, come on up. Dodger. You're such a good boy. Okay. Ciao.